as you can see in there on the bottom of your screen, the Constitutional Court ruling that former President Jacob Zuma is not eligible to stand for Parliament after this month's election. The court has delivered judgment in the Electoral Commission's appeal against the Electoral Court order that essentially allowed the former president to remain as a candidate on the MK party list. Watching those developments from inside court was our reporter Kenny Mapanga, who joins us now live for a sense of the way ahead. And Kenny, of course, the former president being dealt a blow on a number of scores, jurisdiction, whether or not the IEC in fact did have standing to pronounce on his eligibility to stand for this, and comments around Janet Love, the commissioner of the IEC, and whether or not that amounted to apprehensible bias.
Indeed, Ayanda. Well, the Constitutional Court has just overturned the Electoral Court order that paved the way for former President Jacob Zuma to remain on the MK party candidate list ahead of the May polls. What they have stated now and provided clarity on is that Section 47, subsection 1E of the Constitution does apply to the former president. Remember, this section states that if you have been convicted and sentenced to 12 months or more imprisonment without the option of a fine, you are disqualified from being a member of the National Assembly, and that disqualification exists, or ends rather, 5 years after the sentence has been completed. So we know that the former president was convicted and sentenced in 2021, so we could be looking at him being eligible at around 2027 or 28, if I'm not mistaken. So it's still a long while before he can stand to be a member of the National Assembly. So this means that he is disqualified by the Constitution, not the IEC, and that the IEC was not incorrect when it made that determination in March to disqualify him based on the two objections that they received or upheld from the full over 20 objections that were received by the IEC regarding this conviction and sentence. Now, the IEC has gone through the Electoral Court order in detail to sustain their reasoning regarding why the former president is disqualified. Now, they're stating that the Electoral Court erred when it stated that the drafters of the Constitution rather recognized the right to appeal, and they've also stated that with respect to the remission of sentence, that the Section 47 subsection 1E applies to the sentence imposed by the court, not the sentence served. So that with the former president, what this means is that the sentence imposed on him was 15 months and the sentence served was 3 months due to the remission of sentence granted by the president. However, the manner in which you must read that section is through that sentence imposed, which is 15 months. So that means the sentence still stands even though he was granted that remission. Then, of course, you may remember the Electoral Court decided not to decide or determine on Janet Love's statement because they found that the statement was ambiguous and that there was no evidence before the Electoral Court at the time to show that there was a reasonable apprehension of bias. Now, the Constitutional Court agrees with that ground of the Electoral Court and has made the same finding. And after that delivering of that judgment and handing it down at 10 a.m., they have concluded that Section 47, subsection 1E does in fact apply to the former president, as there was a conviction and a sentence. And as a result, that Electoral Court order was set aside, and it was deemed by this court that the former president is disqualified by Section 47, subsection 1E.
Yeah, it was interesting to kind of listen to the reasoning, because I mean, part of what the IEC wanted was clarity. Actually, that's the the refrain, if you like, that they kept going back to. The reasoning that the Constitutional Court found here is that the Electoral Court's decision is actually not substantiated by the text, because when the Electoral Court came out with their decision, they had essentially, their reasonings, they had found that, in fact, the former president cannot be disqualified because the decision to send him to prison wasn't appealable. And the Constitutional Court has now come out to say that, nothing in the actual text itself, nothing in Section 47 1E substantiates that thinking.
Indeed, Ayanda. Well, the Electoral Court spoke of the Constitution and how the drafters of the Constitution recognized the right to appeal. But the task of this Constitutional Court was to interpret Section 47, subsection 1E. And you do that by looking at the text. And the text does not state what the Electoral Court had found in its reasoning. Therefore, it was not sustainable to uphold that finding by the Electoral Court. And they had to read the text exactly as it states. And if you look at the text, it doesn't give all those qualifications, Ayanda, meaning that the former president does qualify under Section 47(1)(e), but is disqualified rather by the section to be a member of the National Assembly. So his conviction and sentence does apply to this particular section, and that is how the Constitutional Court was able to determine that he was disqualified. However, I'm not sure how of an impact this will have on the former president, because all this means is that he cannot go to the National Assembly. However, he remains a leader of the MK party. He is the face of the MK party, and you can expect, or rather it has started because voting abroad happened over the weekend. You can expect that his face will be on that ballot when voters do go turn out on the 29th of May to mark their X in the various voting districts across the country. We don't know if this will have any effect to those voters, because we know that some voters may approach the election with wanting to know exactly who they're going to be sending to the National Assembly or the provincial legislatures when they vote. Now that we know that the former president is not eligible, that almost gives away this argument or this claim that he has given to his supporters and his voters that he had unfinished business to complete in the work of Parliament as well as the work of the presidency. Now we know with the first, as we discussed earlier, Ayanda, that he is not eligible for another term as the president because he has completed 2 terms. But even before we even get there, because the president is counted from those 400 members of the National Assembly, at least for this election, that is the 2024 general election, he may not be a member of the National Assembly as he is disqualified by the Constitution. Then, of course, this judgment, another thing that it does vindicate the IEC's contention that they could have come out with a result that could have been disputed following 29 May if it was not resolved prior to the elections. So the IEC has a bit of a reprieve now because it's going to an election where they have correctly decided on the determination of former President Jacob Zuma's eligibility, and they've lowered the risk of anyone questioning or doubting the election outcome come the 29th of May.
Yeah, you know, admittedly, Kenny, this is a question probably for the IEC, but I don't remember a time where somebody whose face appears on the ballot isn't eligible to actually go to Parliament. So in some ways, we still are in a very unique kind of arrangement where, you know, an individual who is a leader of an organization is the face of the organization, even on the ballot paper, but we now know cannot represent the people who vote for that organization because he can't go to Parliament. It's different.
Absolutely, and as we've stated earlier, this is quite a rare instance for the former president. You have someone who has been convicted and sentenced in the Constitutional Court and then having to decipher what this means in terms of Section 47(1)(e). The country has not been faced with this kind of a question before, but it is quite interesting that the MK party will be heading to the polls led by the former president Jacob Zuma, who actually cannot stand to serve in the National Assembly or realize any of these goals that the MK party is promising its supporters. It's either members who are eligible who will be able to go to the National Assembly rather on the 29th of May. However, the former president, as the leader, as the influential political figure that has lent his name and support to the MK party since the 16th of December announcement, now cannot do anything further from being a leader of that political party. He can't go into those structures and realize some of those promises that he has made to the supporters. So it remains to be seen whether this does affect how voters approach that booth on the 29th of May, or whether they'll still remain loyal, the supporters that is, to the MK party, despite the fact that it's quite clear and the Constitutional Court has clarified in clear terms that he will not be heading to the National Assembly until 5 years after that disqualification ceases.
Yeah, absolutely. The Constitutional Court finding it important for people to know who they are voting for and what the implications are. Certainly part of the reasoning that they explained as they gave out that judgment. Kenny Mapanga, for now, thanks very much indeed. I know there's a whole lot more reaction, of course, to be garnered given the implications around this particular ruling. But yeah, for now, as things stand, the former president, you'll certainly be seeing his face on the ballot, but don't expect him to see him take up a seat in Parliament, no matter how well or not the MK party does.